Here's a move that's about to ignite a massive legal battle between California and the federal government, and it could reshape how law enforcement operates nationwide. California has just thrown down the gauntlet against what Governor Gavin Newsom calls Trump's America by becoming the first state to outright ban law enforcement officers from concealing their faces while on duty. But here's where it gets controversial. This isn't just about local cops. The Democratic governor put pen to paper on groundbreaking legislation known as the No Secret Police Act, which prohibits law enforcement personnel from wearing masks during their duties. The only exceptions? Riot control equipment, medical face coverings, and legitimate undercover operations. Everything else is now off limits once this law kicks in next year. Newsom didn't mince words when explaining his motivation, describing scenes of masked federal agents conducting detentions as something hidden from accountability, any transparency, any oversight. He went further, characterizing the practice of masking as a new construct conceived to terrorize our diverse communities. Strong language that's sure to ruffle feathers in Washington. The timing of this legislation isn't coincidental. California has witnessed an unprecedented surge in immigration enforcement activities, particularly throughout Los Angeles, where masked federal agents have been conducting street-level detentions. These operations often involve agents who refuse to display badges or identify which agency they represent, creating what critics describe as an atmosphere of fear and confusion. And this is the part most people miss. The legal implications here are absolutely massive. We're talking about a direct confrontation between state authority and federal power that could end up before the Supreme Court. Raquel Aldana, a law professor at UC Davis, explains that California is essentially testing the boundaries of what federal agents can and cannot do within state borders. She poses a compelling question. If states can't regulate federal law enforcement conduct, where exactly do we draw the line? At some point, the answer has to be no. Aldana argues, and I think this is what the state of California is trying to do. This raises a fascinating constitutional question about state sovereignty versus federal authority. California is arguing that there must be limits to federal overreach, even when it comes to immigration enforcement. Other states are watching closely. New York and Massachusetts are already considering similar measures. But here's where the controversy really heats up. Immigration and customs enforcement officials have remained notably silent on this development, declining to comment when pressed by media outlets. However, ICE has previously defended mask-wearing practices, claiming their agents need facial concealment to prevent being identified in social media posts that could lead to threats against them and their families. That's a reasonable concern, right? Or is it just an excuse to avoid accountability? The law enforcement community in California is absolutely furious about this development. Multiple organizations representing local police agencies have come out swinging against the legislation, with some using surprisingly harsh language. Riverside County Sheriff Chad Bianco, who's making a run for governor in 2026, didn't hold back in his criticism. He accused Newsom and Democratic lawmakers of prioritizing the safety of criminals over police officers. His most explosive comment: every single person that voted for that needs to be eliminated in the next election. Anyone that votes for those people are absolute idiots. That's pretty inflammatory rhetoric from someone seeking the state's highest office, don't you think? The California State Sheriff's Association, along with the California Peace Officers Research Association, representing over 80,000 public safety members, and the Police Chiefs Association, have all branded the legislation as both reckless and dangerous. They argue it puts officers and their families at unnecessary risk. On the flip side, immigrant rights organizations are celebrating this as a crucial step toward transparency and accountability. Giselle Garcia from NorCal Resist, a Sacramento-based group that provides legal assistance to immigrants facing deportation, sees this law as potentially game-changing. Garcia's organization has documented disturbing incidents where their court observers were verbally harassed and physically assaulted by ICE agents wearing masks who refused to identify themselves when asked. Even if the law proves difficult to enforce against federal agents, she believes having it codified provides a foundation for future legal challenges against government abuse. But there's a significant catch that weakens the law's potential impact. The mask ban doesn't apply to California's state-level law enforcement agencies, only to local police departments and sheriff's offices. These agencies, which typically operate without masks anyway, now have until July 2026 to develop policies complying with the new requirements. Newsom didn't stop there. He signed several companion bills that further restrict federal immigration enforcement activities. One requires all law enforcement officers to clearly display their names or badge numbers while on duty. Another mandates that schools notify parents and staff when immigration agents are on campus. Two additional measures prohibit ICE agents from entering schools and healthcare facilities without proper warrants. These moves collectively represent the most aggressive state-level pushback against federal immigration enforcement in recent memory. California is essentially daring the federal government to challenge its authority, a legal showdown that seems inevitable. The constitutional questions this raises are profound. Can states really regulate how federal agents conduct themselves? What happens when state law directly conflicts with federal enforcement priorities? And perhaps most importantly, where do we draw the line between legitimate security concerns and the public's right to know who's exercising government power over them? This isn't just a California issue. It's a fundamental question about the balance of power in our federal system. The outcome could influence how law enforcement operates across the entire country. So here's what I want to know. Do you think California is right to demand transparency from federal agents, even if it might compromise their safety? Or are they overstepping their authority and interfering with legitimate federal law enforcement? And what about those local police chiefs who say this puts their officers at risk? Are their concerns valid? Or are they just resistant to accountability? This debate touches on some of our most fundamental values: public safety, government transparency, immigration policy, and the proper balance between state and federal power. There's no easy answer, and reasonable people can disagree. What's your take? Should law enforcement officers have the right to conceal their identities while exercising government power? Or does the public's right to accountability outweigh those concerns? The comment section is yours. Let's hear where you stand on this explosive issue.